SCOTUS, the Supreme Court, is on the verge of gutting the Voting Rights Act completely. Now, put it up for a mass. We have a story, a saga, and a warning. The last remaining piece of the 1965 Voting Rights Act, Section 2, which empowers the federal government to protect you, to protect voters from racial gerrymandering meant to dilute Black political power, appears to be headed for an ultimate end. Now, years ago, I said this will become the story, not them taking the section away, but them taking it all away. At oral arguments in Louisiana, in Louisiana versus Callais. Wednesday, the U.S. Supreme Court appeared ready to strike down Section 2, effectively completing the gradual nullification of the Voting Rights Act that it has pursued for over a decade. Now, I want to explain the Voting Rights Act because some people have misconceptualized what it means, misinterpreted based on the title. You have a right for your ability to vote to be protected. Okay? It's a protection dynamic. Your right to vote is an access dynamic. Protecting that right becomes an extra layer in order to shield from violation of that constitutional right. And because of what happened in the 60s and beyond, and frankly, what happened since the beginning of this country, where white political power was preferred. And so the systems that they created, such as paying taxes to vote, would eliminate Black folk who were poor. So that used to be a thing. Counting how many jelly beans in the jar, they called it the intellectual test. That became a thing. This was a real thing in multiple jurisdictions across the United States of America, specifically in the South. So protections had to be in place for this. So that's what we're talking about. The case stems from new congressional districting, these maps that were drawn in Louisiana after 2020. This was after the 2020 census, where you have your population density, which found both that the state was eligible for 6 seats in the House of Representatives, and that its population was about 1/3 Black. The state initially drew maps that featured only one majority Black district, congressional district, rejecting 7 more racially fair maps. Voters sued, and the federal courts ordered Louisiana to comply with the Voting Rights Act by drawing new maps in which Black voters would be a majority in a second district, thereby reflecting their share of the population and giving Black Louisianans an equal opportunity to elect representatives of their choice, okay? But now, a group of people identifying themselves as, quote, non-African American voters have sued to get those racially proportionate maps thrown out, arguing that enforcement of the Voting Rights Act violates their rights under the 14th and 15th Amendments. They claim the maps drawn to remedy racial discrimination against Black people, in fact, constitute racial discrimination against non-Black people. The court seems likely to side with them. I'm going to take you back once again to an op-ed I wrote a while back. And in that op-ed, the context at that time was about affirmative action. We even had some people on the left who agreed that affirmative action should be done away with. I actually read the ruling. The ruling to get rid of affirmative action becomes the context for case law. And that case law becomes the context as a chess move to get rid of anything that protects any historically marginalized community. And that is exactly what's being argued in this case. And if you accept the previous decision by the Supreme Court as it relates to affirmative action, your judicial and legal logic has to then assume that the same logic would apply here. This is why I encourage us to play chess and stop playing checkers. You get no win from getting rid of affirmative action because they use that as a tool to make sure everybody around you and yourself lose. They're utilizing these as tools. But if they do, it will end the mark. It will end the Voting Rights Act as we know it, widely considered the crowning achievement of Dr. Martin Luther King Jr. and so many during the Civil Rights Movement, which the Supreme Court under John Roberts has been dismantling for many years. In 2013, that Shelby versus Holder, the court struck down much of Section 5, which had required jurisdictions with a history of racial discrimination in voting to get federal pre-clearance for changes to its voting laws. In subsequent cases, the court has repeatedly narrowed the conditions under which litigants can bring voter rights claims and expand their state's leeway to make voting laws that would have previously been deemed discriminatory. So the first thing they gutted was the pre-clearance rule, which basically said in order for these states to change how voting is done, they must get pre-clearance from the Department of Justice. That was a standing rule given the historic violation of these states. So basically, this is what we would call a federal decree at a police department. You've done all these bad things. You make this decree and we'll leave you alone. But you got to do these things for us for a certain amount of time. All right? Writing in the majority, for the majority in Shelby, Chief Justice Roberts claimed that racial animus and inequality had diminished enough. I mean, he obviously is aware he's a Supreme Court justice. He's aware that racial animus and inequality had diminished enough that such a regime was not necessary and indeed violated the rights of states. As states imposed a slew of new voting restrictions in the aftermath, the gap between black and white voter participation rates grew dramatically. It expanded twice as much in districts that had previously been subjected to the Section 5 pre-clearance regime. On Wednesday, the court seemed determined to apply the same logic that it used in Shelby County to Section 2, demanding that Nelson, the head of the NAACP's Legal Defense Fund, justify why Section 2 should still be in effect and should not be considered to have somehow expired. Now, let me talk directly to Attorney Nelson. Attorney Nelson of the NAACP, and please somebody get this to Attorney Nelson, and I will have a conversation with Attorney Griggs. Attorney Nelson, you will not win this based on the element of discrimination alone, but you can use their previous ruling to leverage this one. The best argument, or one of the best arguments in my opinion, is this. When the court said that we now have come to a place of post-racial dynamics in our democracy, that we no longer need pre-clearance in the Voting Rights Act. That was a gutting of the Voting Rights Act. So it says, because people are less racist than they used to be, we need to get rid of this. And they did. Now we have data. Since getting rid of that, every single state that was a historical violator has become a historical violator again. Every single one of them, 100%. There are no exceptions to that. Every state that required pre-clearance has decided to abuse that authority, where the courts have had to overturn the decisions that they have made after they gave them the permission to make the damn decision. Utilize that as the reason, because this is not simply about stopping racial discrimination. This is about stopping the potential for racial discrimination in the future. And if you get rid of these safeguards, the same thing that has happened in the previous gutting of the Voting Rights Act is going to happen in the elimination of it. That, to me, is one of your best arguments, all right? So Justice Kavanaugh and Alito asserted that the racial gerrymander was justified if it was indeed or intended as a partisan gerrymander, which is ironic, isn't it? It is legal to gerrymander based on politics or based on Democrat, Republican, et cetera. That is that the lawmaker stated a professed intention, what mattered, and not the racial discrimination or the impact of the gerrymander. Let me explain this in a very simple term. Here's the code that they're speaking. Here's what they're saying. Now, what they're really doing, according to these justices, they just want more Republicans to vote for them and less Democrats, which ironically is acceptable in the language of the rule. It just happens to be that all of the white people are Republicans. So they should be able to do this because, politics and partisanship. That's the code. Previous Supreme Court precedent, as well as ample evidence from the congressional record, has said that discriminatory impact rather than intent, need you to follow this because this got a lot of folk scratching their head. Discriminatory impact rather than intent is sufficient to constitute illegal racial discrimination. But at oral argument, the Republicans on the court, along with those representing the litigants, did not seem to think that should matter. So the previous standard was that the racial or the racist impact that it has is actually more important than whatever non-racial intent you may proclaim to the court. Very simple, very fair. Now they're turning that. Justice Brown, Justice Ketanji Brown Jackson, during oral arguments would fight this. Here it is.
I don't understand why your answer to Justice Kagan's question about, is this a compelling state interest, is no. The answer is obviously yes, that you have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too far in your remedy is another issue, right?
Your Honor, I think step zero in all of these cases, it was certainly step zero in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second majority.
No, it's not, because again, just trust me on this. The second electoral or second district is a remedy that one could offer for a problem that we've identified. And the whole Robinson litigation was about identifying the problem. Is this really happening? In many Section 2 cases, the court says, you're wrong, you're fine. There is not an electoral opportunity being denied to you, go away.
As she rebutted these arguments, in the guise of asking questions from the bench, one could hear the exhaustion from our sister, from Justice Ketanji Brown Jackson. The remedies, she sputtered, quote, are so tied up with race because race is the initial problem. I'm going to repeat that. She said it is so tied up with race because race is the initial problem. It was never politics. Politics is an expression of the racism. Jackson has been the court's most passionate and articulate advocate. We can thank Biden for that, for the Reconstruction Amendments and for the legacy of civil rights movement, but she seemed to know that her colleagues were not listening to her. If the Supreme Court rules in favor of the, quote, non-African-American voters and vacates what is left of the Voting Rights Act, as they are expected to, then a decision will probably come down sometime in June, just a few months before the November 2026 midterms. The resulting racial gerrymanders are expected to net Republicans 19 additional House seats. Here's more on how that could happen.
So this is what the party pickups would be for congressional districts. Republicans, 5. Missouri, 1. North Carolina, 1. Ohio, 2 or 3. Indiana, 1 or 2. Florida, still discussion down there, but that could be another gold mine for them if they tipped it even further their way. Kansas, 1. New Hampshire, 1. And Nebraska. Democrats, Utah, California, Maryland. Look at this. If you offset California and Texas, Missouri and Utah, North Carolina and Maryland, everything left over is an advantage to the Republicans. And don't forget, the Supreme Court is considering what could really be the end of the Voting Rights Act, which would protect minority groups. So you don't have a state that's half black, for example, that elects only one congressional member and everybody else goes to the Republicans that would represent that population in some ways. So if that is gutted, Democrats could lose 19 seats.
When Republicans are confident that the Supreme Court is going to kill the Voting Rights Act, they will finish gerrymandering the House, and America, as we've known it since 1964, will be dead. And this could all go down very soon, within like the next week or two. As soon as Republicans are confident through back channels that the Supreme Court is going to kill the Voting Rights Act, Senate Republicans will eliminate the filibuster and go full one-party rule on America. The idea that the Constitution represents all Americans will be dead, and 170 million of us will have no access to power. And by the time politicians and people realize what has happened, it'll be too late. The country will still hold elections, but the outcome will already be decided before a single vote is cast. And people who warned them will be called paranoid right up until the moment they were right.
Now, I know that seems doom and gloom to so many, but I want to remind you of something. Black folk had no rights in this country at one time. Women had no rights. Black men had the right to vote before white women did. Women could not sign contracts, so your divorce rate was 1%. Because they could not sign a contract of divorce, they could not sign a contract for a home, they could not sign a contract to be a vendor, a business owner. 1958. Black folk, along with our white allies, our Jewish allies, our brown allies, we came together. We did not have the majority of nothing. You didn't have a majority of congressional seats. You did not have a majority individuals in your city elections. Matter of fact, the city elections were keeping you from voting. You could not sit on juries because you couldn't register to vote. So injustice was done right in front of you. 1960s. That level of discomfort became a movement. It became a movement without them displacing one elected leader at that time. They worked with the elected leaders and they forced them to change their ways. They may not have changed their heart, but they changed their vote. I say that to remind you of the immense light, opportunity, fight, ability, capacity, power that you currently have, because you have more than what our folk had back then. They have given you a blueprint. You can stand on their shoulders rather than underneath them. You have more than what you think. So I want you to know, with all of that, you still have the option. And I believe every one of us will be victorious if we do not allow the doom and gloom report to stop our light from shining. All right, dear brother, thoughts?
In 1812, Governor Elbridge Gerry of Massachusetts decided to draw very irregular shaped districts that look like salamanders to the Boston Globe in order for his political party and himself to benefit. That's where we get this term gerrymandering. Do you know why I know? Because I learned it in 3rd and 4th grade in civics class, in history class. And we are doomed to repeat history if we do not know our history. So please know this. Please know that our 15th Amendment and our 19th Amendment, which are the rights to vote for all people, and 19th for women specifically. And when I say all people, I mean people of color, because that's who was restricted. Remember that these are the fights that people all over the world are fighting, and here we are now refighting them at home. This should not even be a decision that needs to be made or put forth. This needs to be substantiated, not just by our generation's Thurgood Marshall, who has taken the form of Justin Ketanji Brown. This is by all the justices in the Supreme Court. And please be aware of who votes against this, because they are voting against you as a human being. This 1965 Voting Rights Act was not just meant for Black people. It was meant for the American people to unite this country. I live in Los Angeles, which is one of the most gerrymandered districts in the country because of how things are shaped, whether they want to admit it or not. What I'm saying is, here at least we have so many different people in so many different places that those gerrymanderings have been thrown out the window. Do not let them throw your right to vote out the window, because first they come for your right to vote, then they come for you. And to all the black people out there, this is why I say all of us need to move to Minnesota, Idaho, Maine, Connecticut, and Vermont, low population places, so we take over and we have 10 senators at any given time, and then let's see what laws they try to change then. See what laws they try to move around at that point. They'll be like, oh, well, no, now we shouldn't have 2 senators per state. We should, exactly. It always comes down to that. If it's not about race, then what it's about.
And we know that the right to vote fundamentally is a protection of every other democratic right you have. And you also know if the right to vote is protected for minority classification, they can't touch your right to vote ever.
And if I could just say, Dr. Richey, it's not about just your right to vote. It's not the act of voting, like, oh, here, I voted. It's about your vote's right to actually count. That is what they want to do. Remember these words: diminishment, dilutement. That is what they do. They use words and terms that march around things in order for it not to directly say what they want to say. But they are saying this the same way that it was rephrased that black people asked for a black district when that's not the words they would use. What they're saying is, we want to make sure black votes do not count.
Yeah. Well said, dear brother.